do that before, so I'm like, ah.
Yes,
I was
Jody.
just wondering.
Prepare for constant change. Things are going to be constantly changing all the time, not just at Rasmussen, but everywhere in the high tech era. Every time, a new version of a learning management system comes out, every time new software comes out, every time anything happens, there's going to be ton of change in the future. Everything you've ever known, just like living in the post pandemic world versus the pre
Yeah.
pandemic world, everything we knew before is gone, and it's only going to continue to change.
I agree on that one.
The
So,
only thing that's staying the same is the law, because it's rooted in a firm history of thousands of years.
yeah.
It actually is more or less pretty stable based on the doctrine of stare decisis, but anything involving technology. So yeah, now
It,
all.
it's hard
Mhm.
to keep up. It's very hard. I'm in the older generation. I'm trying to keep up as it is.
Oh yeah.
So,
I
yeah.
remember programming. I was programming Commodore 64s like in 1982. So, you
Yep.
know.
Yep.
No,
We're
we're not
probably
done yet.
close. Yes.
We're not done
Yes.
yet. We're going to continue to change. As we can see right now, we've got billionaires sending rockets up to the moon. And really, that rocket could just be used to take them from London to Japan. If I
I
had a
know.
rocket, I would just use that to travel to Europe. Not, I wouldn't just float outside the Earth's atmosphere for 15 minutes and then come back. I would actually use the rocket, for a vacation, to go to France or somewhere nice like that,
Yeah.
rather than
Yeah.
being on a plane for 15 hours. If you have a rocket, you're Jeff Bezos, Richard Branson, you could just take your next trip to France in your rocket and probably get there in, like, I don't know, 25 minutes.
I know. Or take that money and help the economy, instead of being so greedy. I just don't pay attention to those. They're BS to me. They're all
Yeah.
BS.
Well,
You know?
honestly, Jeff Bezos has created 1.3 million jobs. So, they
Yeah.
are stimulating the economy in many, many, many ways. And, it's just that maybe he could pay his workers a little bit more.
Uh-huh. Definitely. I agree on that.
Yeah.
So, but are we going to be discussing about the discussion that the ethics?
Yes.
Yes, yes, that is quite interesting. About the unrepresented client. You know, is it's a little confusing. I don't think we touched that in your ethics class. We touched other things.
Yeah, we didn't go into that into detail. So we're going to tonight. Let's get started.
Oh,
Welcome,
good.
Jody. Welcome, Kara. Welcome, Adrian. And welcome, Corinne. Great to see you all back. Welcome to Module 3. This is our live session for the contracts course. So let's take a look at our assignments. The first assignment is to read the Uniform Commercial Code and the Restatement of Contracts. So on the Uniform Commercial Code, portions of that have been adopted in every state through statute. So the Uniform Commercial Code is a primary source of law. The Restatement of Contracts is like an encyclopedia about contracts. It is a secondary source of law. It's a treatise. The Restatement of Contracts is like reading as a treatise about the law. But the UCC is composed of state statutes. It is the law governing the sale of goods. So let's take a look at what's going on here. So in Module 3, you have a written assignment that is building on that IRAC that we discussed last week. What does IRAC stand for, Corinne?
I know the C is definitely conclusion.
Okay, good.
I think A is analysis, possibly.
Yes.
Uh,
Yes.
R, research, maybe. Rule.
Rural.
Um, and gosh, I can't remember.
Okay. You were 60% of the way there. So IRAC is an acronym, which is where you take the first letter of a phrase and make that a word. So issue, rule, analysis, conclusion. So it's an acronym for issue, rule, analysis, conclusion, and it is a way of analyzing the legal issues that are in any case or any scenario that you may be dealing with. So this module 3 written assignment involves a scenario where you have new clients and you receive a research assignment from your boss to update your firm's research notes on offer and acceptance. Your firm keeps research in electronic folders so anyone in the firm can get updated on what others have found. So it is important to provide complete references. So this is like you're writing a legal memorandum summarizing the law of offer and acceptance. So, that's why it's telling you you can look at this you can look at this treatise on offers and read the Uniform Commercial Code provisions on offer and acceptance. So read about the offers in the restatement of contracts. It's a treatise. And then do the following. Find a very recent offer and acceptance case using either Lexis Advance or Fast Case. Those are boutique research services that are going to give you the best bang for your buck. You are paying for computer assisted research so that you can find the most recent, current, up to date, and trustworthy information about the law. So you want to find a recent case about offer and acceptance, one that has not been overruled, for example. So when you're doing this search in advance, Lexis Advance, sort by date, newest to oldest. When you find that case, you're going to do what every law student has to do, which is to prepare a brief of the case using the IRAC form. What is the issue in the case? What is the rule? What's the analysis? And what is the conclusion? 2, find a recent article on the internet about the law. There's tons of blogs about the law. I did some searches today. One that talks about offer and acceptance. All you have to do is Google contract offer and acceptance, and you're going to get tons of blogs. So you pick one article that you find when you Google that, and then summarize it and cite to it. You can use an APA site or a Blue Book site. Probably be an APA site if it's an article on the web. Which of the sources helped you most in comprehending the law of offer and acceptance? Was the case more helpful, or was the information on the open web, was that more helpful? Let us know why. 4, find and cite an applicable portion on offer and acceptance in the UCC or the treatise. Use Blue Book citations just below each use of a legal source and an article in your blog. All the uncited portions of the paper need to be your personal analysis. So yeah, you can just find a UCC rule on offer and acceptance, cite to that. You can find a paragraph in the restatement second of contracts that talks about offer and acceptance and just cite to that. So it's a 4-part assignment. The best way to approach it is to take your time, do one step at a time. If you have any questions at all, contact Dennis. He's the law librarian. He can help you do searches on Lexis Advance. Any questions about the Module 3 written assignment?
Yes, ma'am. It's
Okay.
Adrian. You know I always have questions. So I'm basically done with it, but I just want to make sure I did it correctly. So a couple questions. One, we're doing the IRAC, the number 1 as a memo, correct? Issue, rule, analysis, conclusion, correct? And a
Yes.
memo for, like, to you, from me, date, all that. Is that how you?
Yes.
Okay. Okay, thank you. That was the first one. Okay, second, my summary, how long should that be? Is it I've got a page almost, because it wasn't a very long article, but it was very good. So is that okay? Does it matter how long, as long as you know the article I'm talking about and we're writing it correctly? Because we're just
Yes,
summarizing,
that's
correct?
fine.
Okay. And then
Yes.
at the end of the summary, I put number 3, which of the sources helped you most in comprehending the law of offer and acceptance? I put that at the end of the summary. Do you want that on a separate paper? Like why
No.
that?
All
You
together
can go
is
on
fine.
summary. Okay, and then number 4, the number 4 question, do you want that on a separate one too? Like by
No.
itself? Can go on the
One
summary as
P-
well?
One
Okay.
document is optimum because of the way that you submit things in Blackboard. So I would use one Word document and put
Okay,
all
so
your stuff
after
in
my
it.
memo, after the memo, then do number 2, then after that, number 3, and then number 4 all in one for you?
Yes.
Okay. All right, I will put it all together. Thank you. That was it.
Good question. Yep. The easiest way to do anything is just to follow the logical order, go in a straight line. You know, people go through life zigging and zagging and in circles, when the best thing to do, take a deep breath, remain calm, and use logic, go in a straight line. Hi, Tina. How you doing? Thanks for joining us. Any other questions about the Module 2 written assignment? I think it's very straightforward. I really do. And it's excellent. This is the kind of stuff that that law students and legal researchers do every day. If you can do this Module 3 assignment, you can be a paralegal in America, because this is the kind of stuff you will be doing. Okay, so in Module 3, we actually have a discussion forum. I've been missing those. And it's asking you to learn how to handle an unrepresented party. And that does bring up the ethical issues. And Jody was mentioning, I had some of you in the legal ethics class, and we looked at Model Rule 1.8 and 4.3. So let's take a look at our scenario, and then we'll take a look at the rules. So in this scenario, Joe is your supervising attorney. Joe wants you and the others in the office to discuss a contract before she agrees to create it based on the 2 ethical rules, 1.8 and 4.3. Joe, Harry, and Dean are cousins. So your boss is an attorney and she wants to enter into a contract with her cousins. Harry and Dean are buying a boat with the idea that they are going to use it at different times. Dean will use it in the summer. Harry will use it in the winter. Joe has been asked by Harry to review their agreement and turn it into a written contract. Harry will pay the legal bill to Joe for drafting the contract. Harry and Dean want the contract in writing in case one of them dies, so Jill will do a buyout provision. Dean does not want to have a separate lawyer review it. They also want Joe to loan them 20% of the price of the boat in return for a promissory note and a security interest in the boat. They have the rest of the money in cash. Meet with your attorney and discuss Joe's options. Hi, Stephanie. Thanks for joining us. So, Jody, do you see any possible ethical conflicts in this scenario?
Yeah, the one, I forget which one. Dean doesn't want a separate lawyer. They want to just share, or this kind of sometimes happen in family law where if you have a known contest divorce where they'll use the same lawyer for something. Yeah, this could be a conflict of interest because if there's a dispute. Am I correct?
Okay, yeah, you're definitely onto something. One thing is, an attorney cannot represent parties with opposing interests. So this might be a scenario where Harry and Dean have opposing interests, and that would be a factual determination of whether Joe can represent both of them at the same time. What about this thing where Joe is then going to loan them 20% of the price of the boat, and then she gets a promissory note and a security interest in the boat? Can the attorney engage in self-dealing with a client? Can an attorney write up a contract with a client where the attorney is creating a security? Yeah, that's self-dealing. That's a conflict of interest, because the attorney's conflict of, the attorney's interest is going to be to have them pay the boat, and their interest is just maybe to not pay her the boat, so there could be adverse interest. One party's a creditor, the attorney becomes their creditor, and the client becomes her debtor. She certainly cannot be the one to draft a contract when she has a direct conflict of interest with the client, or she can't create a contract where she's going to take an interest in in a piece of property, and it's a secured transaction because of the promissory note. No. So let's look at the rules. So what is the issue in this case? If we're doing our IRAC analysis, Corinne, what's the issue? Does anyone know what the issue would be? Okay, the issue is whether Joe should write the contract for her cousins. What is the sub-issue that has to do with ethics? Okay, that's the broader issue. What's one sub-issue?
Sorry, it's too much to write. It would be, first of all, she would have two clients of the same thing. You can't do that. So she would have to advise one of them to go to different counsel, which she can help with. But that would be another issue right there.
Okay,
It's
you
conflict of
actually gave the
interest.
conclusion. Yeah, you
Oh,
gave the
sorry.
conclusion. That's okay. But so the interest is it ethical for Joe to represent Harry and Dean in this transaction? So it's very important when you're doing an IRAC to get that issue statement correct. So the issue, there may be more than one. The issue is, and I'm going to type this in the chat, is it ethical for an attorney to represent both parties to a sales transaction? That's one issue. Another issue, and I'm going to type this as issue 2, is it ethical for an attorney to draft a contract for a client where the attorney is creating a security interest for herself in the client's property? So those are two issues, right? And they're both conflict of interest questions. Can you represent two parties who are buying a boat in the drafting of the contract? That's one issue. The second issue is it ethical for an attorney to draft a contract for a client where she has a conflict of interest because she is making herself a creditor of the client and creating a security interest in the client's property? The crazy thing is people do this. Go ahead.
Sorry. Well, they're also cousins, so you're not supposed to really represent your family either.
Do you know of a rule that says you can't represent your family?
Well, I think because you know the people.
Okay, so you got to have a rule. Who's talking right now?
Kara.
Okay, Kara. You can do anything you want unless there's a law that says you can't. Okay, that's how our system works. So if you think you can't do something, or that you think a lawyer can't do something, you've got to find a law that says that.
Okay.
So if you don't have a law that says that family members can't represent each other, if you don't have an ethical rule that says that, then they can. An attorney can represent a family member unless there's a conflict of interest. So let's remember what we're learning to do right now is IRAC: issue, rule, analysis, conclusion. We're starting with I because I do everything logically and that makes it work and go in order. I, okay? The first issue, let me scroll back to the chat. The first issue is it ethical for an attorney to represent two parties in a sales transaction? 2, is it ethical for an attorney to draft a contract for a client when the attorney is creating a security interest in the client's property? The fact that two people are cousins, I don't know of a rule that says you can't represent your cousin, Kara. I don't know of one. If you find one, let me know. You could Google it tonight, and I guarantee you'll get some hits. But if you find something that says that an attorney can't represent a family member, let me know. Because unless there's a rule that says I can't do it, in the American system, you can do anything unless there's a law that says you can't. So let's take a look at the first rule. The first rule, let me make sure I got this right. It's okay, 1.8 4-3. 4-3, this is how you deal with an unrepresented person. In dealing on behalf of a client with a person who is not represented by counsel, a lawyer shall not state or imply that the lawyer is disinterested when the lawyer knows or reasonably should know that the unrepresented person misunderstands the lawyer's role in the matter. The lawyer shall make reasonable efforts to correct any misunderstanding. The lawyer shall not give legal advice to an unrepresented person other than the advice to secure counsel if the lawyer knows or reasonably should know that the interests of such a person or there's a reasonable possibility of being in conflict of interest with the client. So here, Harry is paying for the legal bill. So it sounds like Harry and Joe are going to have an attorney-client relationship. Dean, though, it could be seen as an unrepresented party. Dean does not want to have his own lawyer review it. So Dean is an unrepresented party in this scenario. So 4-3 applies. That means Joe needs to let Dean know, hey, you know what, we're cousins, but Harry is my client. He's the one paying my bill. So Joe needs to let Dean know that you need to get your own lawyer. I am not looking out for your best interests, okay? And that's what a lawyer needs to do, and a paralegal also needs to do that. When you're dealing with an unrepresented person, you need to let them know, hey, I am here to represent the client who's paying for my services. I am not representing you. You need to get your own lawyer, and if you choose not to, you've been advised of ABA Rule 4.3. Any questions? So that's our rule, IRAC: issue, rule, analysis, conclusion. The issue is whether the attorney can represent Harry and Dean. The rule is, well, you might be dealing with an unrepresented person here because Harry is paying the legal bill and not Dean. Dean doesn't want to get his own lawyer. Looks like Dean's an unrepresented person. That means ABA Rule 4.3 applies. So that's why the IRAC is so important, to logically analyze the situation. You got to start out with an issue, then you've got to start out with a rule, because otherwise we could be talking about whether Harry's sister's cousin's wife could represent us, right? If you don't have a rule, and that's why you see people today debating stuff on the internet and TV, and they never get anywhere because they haven't really identified and narrowed the issue, or at least they're not focused on it, and they're not focused on the rule either, right? That's why we have so much chaos in society. We're not here for chaos, so we're here to, get it right so you can get your degree and start making more money. So the way to do that is to be very logical, very precise, know what your issue is, and know what the rule is. Is there any question about the analysis and conclusion? Any comments? Everyone's straight on the importance of identifying the issue and identifying the correct rule. Okay, great. All right, now I can see your chat. Let's keep going. So the other rule, so the next question is the analysis. What does rule 4.3 require Joe to do, Corinne? So we know what the issue is. We know what the rule is. Now we're talking about our analysis and our conclusion. What does rule 4.3 require Joe to do?
To get representation.
Say it one more time.
To get representation. Is that what are you talking about, Dean, or?
Joe.
Okay.
The ethical obligation is on the attorney. The attorney will follow the ABA rules or be sanctioned by the state bar, suspended from the practice of law by the state Supreme Court, subject to disciplinary proceedings. So it is the requirement of the attorney to follow the rule. What does the attorney have to do in our situation?
Well, I think you kind of described it in the scenario too, that he would need to speak with Dean and make sure that he has representation. Kind of give him that same disclosure that you had said earlier.
Good, good. All righty, so there's our IRAC for that issue. Now let's get to the second issue. Sometimes a scenario has more than one IRAC. So the second IRAC again is whether it's ethical for an attorney to draft a contract for a client where there's a conflict of interest because the client has some security interest. The client is making herself the attorney is becoming the creditor of the client by loaning the money to buy the boat. So that takes us to ABA Rule 1.8. A lawyer shall not enter into a business transaction with a client or knowingly acquire an ownership, possessory, security, or other pecuniary interest adverse to a client unless the transaction and the terms on which the lawyer acquire the interest are fair and reasonable to the client, fully disclosed, and transmitted in a writing that can be reasonably understood. The client is advised in writing of the desirability and is given the reasonable opportunity to seek outside advice on the transaction because the lawyer has a conflict of interest. The client gives her informed consent in a writing signed by the client to the essential terms of the transaction and the lawyer's role in the transaction, including whether the lawyer is representing the client or not in the transaction. A lawyer shall not acquire a proprietary interest in the cause of action or subject matter of the litigation the lawyer is conducting for a client, except acquiring a lien to secure the attorney's fees or contract with a client for the reasonable contingency fee in a civil case. So this is our rule. What does the rule require us to do, Stephanie? We've got our issue. We've got our rule. What's our analysis? Who's ready to tell me the analysis?
Well, if they do a transaction, it has to be in writing. That's the main thing I caught. And it has to be fair.
You're right, Kara. So Stephanie says she's confused. So what we're doing, Stephanie, is we're at the module 3 discussion forum question, which is a scenario in which Joe's an attorney and wants to represent her cousins in the purchase of a boat, but they need her to loan them 20% of the price of the boat. In exchange for that, she gets a security interest in the boat, evidenced by a promissory note. That's a conflict of interest under ABA Rule 1.8. Going back to your legal ethics course, I don't know if I don't think I was your teacher of that course. If I was, you wouldn't be confused right now. So the issue is whether or not the attorney can represent the client in a contract for the purchase of a boat when the attorney is going to be loaning the client 20% of the money and making the attorney becomes a creditor of the client. The client becomes a debtor. And so that's an issue. We've looked at the applicable rule. The rule is Rule 1.8. Okay, right. So we're doing the IRAC on this, Stephanie. Ethically, the lines would become blurred with Joe's role. Is he the lawyer or the one holding the loan? Exactly. That's a conflict of interest. So we've gone to the applicable rule. We're doing our IRAC. We know what that's the issue, what you pointed out, Stephanie. The rule is ABA Rule 1.8. A lawyer shall not enter into a business transaction with a client or knowingly acquire an ownership, possessory, security, or other pecuniary interest adverse to the client unless the client gives informed consent with all the disclosures letting the client know that the attorney has an interest in this. The client should go out and get his or her own attorney. Now, there's a conflict of interest. The client can waive that in writing. So that's your analysis. And what's the conclusion here, Jody?
I would say that that both both of the clients should have their own representation. That the Joe, if he's the attorney, he should have no interest in the contract. So
You're right. And that would be ideal, but if Harry and Dean are stubborn and they still want cousin Joe to write up the contract, what do Harry and Dean have to do?
They would have to seek legal get another advice, correct, from a different attorney.
That's optional. What does 3 say they can do, Corinne?
Oh, of course, just written consent too. Yeah.
Good. Tina got it in the chat. Give written consent. So you want to make sure you spend a few moments reading Rule 1.8. Throughout the law, there is a rule, and then there's a bunch of exceptions. That's how the law works to provide flexibility, given the kind of commercial transactions and contracts that individuals wish to enter into. The rule is that a lawyer shall not enter into a conflict of interest with a client. The exception is that the client can waive the conflict of interest after giving their informed consent in writing. Any questions? Yes, there's always an exception. And that's the same thing in life. There's always an exception. Always an exception. There are no absolutes. The universe is full of randomness. You may think a rocket ship is going up, and the next thing you know, it catches on fire. That was the Challenger. There's always an exception, right? Because there's randomness. Anything can happen to mess up the best made plans, and you know that when you plan to do something so perfectly and some random event comes and just messes up all your plans. I hate that. But there's always an exception, Adrian. And Rule 1.8 has got several exceptions. So the client has options here. The clients may choose, Harry and Dee may choose to get their own lawyer. And they might still have cousin Joe loan them 20%. And well, what's going to happen when what happens when Harry and Dean run out of money and they stop paying for the boat, Jody? What happens when Harry and Dean stop paying on that boat?
they're in big trouble.
What's
That's a repo, probably a repo, though. And then
Yeah,
there's
Steph,
going to be a lot of more legal actions.
there's going to be some trouble between cousins. Stephanie said it's a breach of contract. It's a breach of contract. And since it's a secured transaction, Joe could foreclose, on her interest in the boat. She could become the owner of the boat. If they don't pay her for the 20% that they owe her, because it's a secured transaction, she can foreclose and enforce that promissory note, get a lien. She can get a lien on the boat. If they don't pay off the lien, the boat becomes hers. Yes, Stephanie, there's obviously some conflicts of interest here. Be foolish to pay the same person for legal fees and a loan. People do it. People do it all the time. That's why we need these ethical rules. So that's what your module 2 discussion forum is it's a review of ethics. Any questions? So I'll see everybody in that discussion forum. Your first post was due Tuesday, but there's still plenty of time to make your post. The reply post is due Saturday. You've got all week to participate in that discussion forum. Any questions before we get on to the module 3 quiz? Has anyone already taken the quiz? Have any of you already taken the quiz? You're smart. You wait for the quiz review. That's when the instructor tells you what's on the quiz. Yes, Adrian is smart. You always wait for the quiz review. I always freak out when I see students taking the quiz on Monday morning and then they get a 40. And I'm like, well, you know what? They did not intend to pass the quiz. Your actions show your intentions. If you wait for the quiz review, that is circumstantial evidence that you intend to pass the quiz with a good grade. If you do not wait for the quiz review and you just take the quiz without studying, that shows your intention to fail the quiz. So our actions show our intentions. So yes, all of you have the right intentions and the right actions. So here is our quiz review. Getting back to the very beginning of what we talked about in module 1, what are the 3 elements of a valid contract, Jody? This is a quiz on contracts covering modules 1, 2, and 3. What are the 3 elements of a valid contract? Anyone know?
Offer, acceptance, and consideration.
There.
Great. Stephanie got it. Offer, acceptance, and consideration. Adrian got it. Good. We talked about that in module 1. Sorry if you lost sound. It happens. Again, not a perfect world. Okay. Do contracts have to be in writing? We talked about that a lot in module 1. Do valid contracts have to be in writing? No. No. What are the laws that apply to service contracts? When an attorney is researching a service contract issue, when a paralegal is researching an issue. For a service contract.
You want to use the restatement contracts or the UCC codes.
When does the UCC apply?
In sales and leases.
Right. The UCC only applies to contract for the sale of goods. What if my contract is that I have hired Britney Spears to perform at my birthday party? What law will govern that? That is not a sale of goods. It is not a lease. What type of contract is that? Adrian says service. So understand, contracts for personal services, You hire someone to paint the roof on your house. You hire someone to mow your lawn. You hire somebody to come to your house and fix your door. You hire Britney Spears to come sing at your birthday party. That is a personal service contract. UCC does not apply. That would be governed by the common law, Jody. Common law is judge-made law found in a body of cases. So that's common law.
Can I ask a question really quick?
Yes, ma'am.
What is the McNamara O'Hara service contract? I was kind of reading up on that. Is that a service contract?
You don't have to know that for the test.
Okay. Well, you know me, I have to over prepare. Okay, thanks.
Yes, you don't have to know that for the test. Okay, so let's get back to the question. What is the primary law that applies to service contracts, Jody? What is the source of law that
Still the restatement.
The restatement is
contracts.
okay. The restatement is a treatise. It is not a primary source of law. It's like an encyclopedia. Laws are cases and statutes. That's it.
Yeah, that's good. Yes.
Okay, so
I forgot about the statutes.
that's okay. So cases are known as common law. It is common to all. It's judge-made law. What is the body of law that governs service contracts? Anyone want to help Jody? Good, it's the common law. It is the law that's common to all, if that helps you remember it. Service contracts, personal service contracts, I'm coming to your house, I'm fixing your roof, does not involve the sale of goods, does not involve a lease. That is governed by the common law. The restatement of contracts is not a law. It is an encyclopedia. It is a treatise. It is not a law. It is not a primary source of law. Primary source of law would be the U.S. Constitution, state constitutions, cases, and statutes. What law applies to contracts for the sale of goods, Jody? What law applies to contract for the sale of goods? Anyone can answer. Can everyone hear me?
Yeah. I can hear you.
Awesome. So yeah, the UCC. The UCC, what is okay, UCC is an acronym. What is it? Adrian, what does the UCC stand for? It is an acronym. It is 3 letters that stand for a
Uniform
principle.
Commercial Contract?
Code.
That's it. I
Okay.
always say that. Okay, thanks.
The UCC is the Uniform Commercial Code. It has been codified and made as part of the statutory law of every state. It is a primary source of law. The purpose of the UCC, Jody, is to make it easier for goods to flow through the stream of commerce, right? To uphold commercial transactions in a vibrant modern economy. That's why if you're dealing with a contract for the sale of goods over $500, we have special rules to facilitate contracts for the sale of goods in a modern, vibrant, economic, free market system. We want those goods to flow freely from sellers to buyers and give them lots of remedies and lots of options to hold commercial transactions. The UCC applies to contracts for the sale of goods, and leases. UCC does not apply when somebody comes to your house to mow your lawn, because that's not a fancy commercial transaction. Okay, let's get back to the 3 elements of a contract: offer, acceptance, consideration. Corinne, does acceptance have to mirror the terms of the offer to create a valid contract?
Yes.
Yes, that's the mirror image rule. Yes, the terms of the acceptance have to mirror the terms of the offer. Otherwise, it would be considered a counteroffer. So if I say, I offer to sell you my cell phone, my iPhone for $100, and you say, yes, I will buy your cell phone for $100, those terms mirror each other. That's the mirror image rule. That means we have a mutual assent. We have a meeting of the minds to the same contract terms. What is the consideration in that scenario, Kara? I offer to sell you my iPhone for $100. You promise to pay for it. That's offer. That's acceptance. What is the consideration, Kara?
Well, it's an oral contract, so the money, one's getting
Yes.
money and the other one is getting the phone. So
Brilliant.
they both
Yep, you got it. Consideration is anything of legal value that is bargained for. It's usually the subject matter of the contract. It's Stephanie put in the chat box. The $100 and the iPhone are of legal value. Those are things people want. There's a value to them. That's what we're bargaining for. We're not just making promises because we're sweet. We're bargaining for something of valuable consideration. So that's the 3rd element of a contract. If you have an offer and you have acceptance, but you have no consideration, you do not have a valid contract. You have to have offer, acceptance, and consideration. And you also have to have the mirror image rule. The terms of the offer and the terms of the acceptance have to match. They have to show a meeting of the minds of the same terms. We talked about this in Module 1. Why would an attorney want your contract to be in writing? Corinne says the written contract ensures that all the terms of your agreement are documented.
I think it's because it's harder to dispute the offer and the acceptance and consideration that was agreed upon because it's all in writing. There's not he said, she said.
Good, good. Yes, it makes it much easier to show you the offer, acceptance, and consideration. It makes it easier to prove the terms of the contract. It makes it easier to prove the consideration. It makes it easier to show the assent if somebody signed the contract. So yes, it makes it easier for the contract to enforce. Okay, so how many of you have worked as paralegals? Corinne works as a paralegal right now. Corinne, what would you do if you found an error in a contract while you were working?
Well, I work really closely with my supervising attorney, so, you know, I would just discuss that with him right away.
Okay. You might highlight the error, and point it out to your supervising attorney.
Absolutely. Yep. If there's an error, we definitely want to know.
Great. Okay. Back to Iraq. We identified Iraq is an acronym for what, Adrian?
It's issue, rule, acceptance, or analysis, and conclusion.
Yes. Issue, rule, analysis, and conclusion. You take the first letter of each word of a catchy phrase and you make an acronym. UCC is an acronym. IRAC's an acronym. Why did we use the IRAC tables in modules 1 and 2? We had them in Microsoft Word. Is there another way to do an IRAC without a table?
Yeah, you can do it the long form, like in the legal memorandum, but the tables just shorten everything up, and it's easier for the attorney to identify the case itself that they're working on.
Okay, great. Kara, what is the restatement second of contracts?
I'm gonna be honest, I don't know.
Jody knows what it is, though.
Yeah, I kept getting it goofed up. Yeah, it's second source, and it's a treatise, like you mentioned. But the that's why I always get it confused, is because it's a second source, but a lot of judges and attorneys uses almost like a primary source. They go
It's
they
not a
go
primary source. You were good until you
no,
said
and
that.
they use it like a primary source. You
All right.
misunderstood me.
I'm
But
just
it
kidding.
is a secondary source, but they use a lot of it. Actually, in a personal injury case, I read it, they were using the restatements, in torts a lot. So,
You
yeah,
can cite to it. You can cite
yeah.
to it in the court of law. Jody is absolutely correct. You can cite to it, in a court of law. It is respected. It is a treatise. It's an encyclopedia of the law. It's okay to cite to it, as long as you recognize it is a secondary source. Why is it secondary? It talks about cases and it talks about statutes. And you can just go to the law itself. You just read the UCC, right? Read the case. It talks about offer and acceptance. When you look at the restatement, you're looking at an encyclopedia where somebody else tells you what the case means. Some attorneys want to know for themselves what the case says, because they might want to use the case to demonstrate something different. So that's why it's important if you're going to actually rely on a particular case, if your case that you're working on is relying on a certain case from the past, you want to make sure you've read that case, not just what somebody says about the case. So the restatement of contracts is very reliable. I personally like Corbin on contracts. I find that that's better. There are other people who have written about Williston on contracts, is also a very respected treatise. So these are just encyclopedias. A lot of people rely on them because they give you a great summary of the area of the law that you're looking at. However, you still need to do your research on Lexis Advance and get your most recent cases, because those treatises are old. They do get updated, but they're not going to give you the freshest, newest, hottest trends in the law. You'll need to do research on your boutique services for that. Which takes us to our next question. Why do you use Lexis Advance and Fastcase, Adrian?
Well, then you can look up the latest statutes and cases on whatever you need to look it up for, in this case, contracts.
Does the restatement of contracts tell you if something's been overruled?
You mean like if yes, it does. They can use that towards, but is that what you mean? Because some of the things I read, yes, they used it for that, to show that, that maybe that needs to go back to the district court, because I'm not making sense, but sorry.
You're making perfect sense.
Okay.
I need to rephrase the question. If you pull a case off of Lexis Advance for your assignment, like you did, and you pull a recent case on offer and acceptance, Lexis Advance will tell you if your case has been overruled, right? Do the shepherdize this? Okay.
Yes.
Does the restatement of contracts shepherdize?
No.
There
No.
you go. That's why you can't rely on that in court. If a lot of money is riding on a particular case, you need to make sure that the case you are using is good law. Why? There are cases that I learned when I was in law school that are no longer good law. Can you believe that? If you were to cite to one of the cases I learned in law school, a judge would laugh you out of court, right? I'll just use gay marriage as an example. When I was in law school, gay marriage was illegal. And there were Supreme Court cases I could cite to that said, here's one right here that says it's illegal. And I might be looking in a treatise, and that case might be in there, and then I might think, oh, I'm done. But when you get on Lexis Advance, it's going to tell you what the case law is up to the minute in 2021, not from a treatise that was written 100 years ago. Okay, so that's why you need to use Lexis Advance and Fastcase. They're premium legal research services that tell you up to the date what the law is now, and if there's been subsequent treatment of a case. You know, for example, if I was citing to a case that I learned in law school that said gay marriage is illegal, Lexis would show me the subsequent treatment of the case and when the case was overruled by the U.S. Supreme Court when they held that gay marriage is legal. So that is why you need to use the most up-to-date information, because everything's changing. Look at the amount of change we've seen in our lives. It's been very drastic and it's constant, and cases are coming out every day that have the potential to change the law. And also, Jody, the restatement has really generalized principles of the law. There are certain exceptions that apply in California that the restatement may not know about. There's certain exceptions. You're in Chicago, in Illinois. Are you in Illinois or Minnesota? So either one of those states, if you look at certain trends in the law in the South versus how they're interpreted in the Midwest, is different. So that is why you can't rely solely on a secondary law source, because an example would be community property. On the West, there we have community property states. That means everything the husband earns during the marriage, half of that money goes to the wife. That benefits women.
Yeah.
Alabama is not a community property state, okay? Neither
Oh,
is
no.
Virginia. So if the restatement is talking about community property in its very generalized way, and you're dealing with a client that's in California, you better know what California divorce law is as of 2021, and you'll find that on Lexis Advance. So that's why we need to be very up to date. It's funny, even during the horrible OJ trial in the 90s, Marcia Clark, the prosecutor, cited a case, and the judge said, "Did you shepherdize that?" And everybody's like, "Whoa." The judge is like, "We were in law school, right? And you learned how to do legal research, Miss Clark." She's like, "Oh, I think we shepardized it," you know? So, yeah, some judges will clock people in court if they cite to a case and the judge knows that that case has been overruled, and they could have done a search on Lexis Advance and found out before they went to court that day that case was overruled yesterday, you know. So, is everyone straight on why it is important to use Lexis Advance and Fastcase? Let's get down to the UCC. What does the UCC stand for, Jody? Can anyone tell me what the UCC stands for? I'm making little letters.
Yep.
UCC.
Same.
What does it stand for, Jody?
Uniform. I thought I said it. I thought I had my mute. It was mute. Uniform commercial code.
Good, good,
So,
good. Awesome. You all are really catching on to this fast. So, yes, it's a uniform commercial code. It has a specific purpose to facilitate the free flow of commerce and the sale of goods through interstate transactions. What are the seller's duties under the UCC? What are the seller's duties under the UCC?
I'm just going to say it's too much to type. Make sure the delivery is when they have contracted for the time. Make sure that it's conformed goods, not non-conformity goods, because then non-conform, obviously they have 10 days or whatever the contract says to get them to conform goods. What else? I mean, there's a couple more, but those are like the big things.
Good. What are the buyer's duties under the UCC?
They can either accept or reject it and receive the money. So, and they have to notify if they're going to reject the non-conform goods as soon as possible. So it gives the chance the seller to cover, the non-conforming goods with conform goods.
Good. And of course, pay. So the buyer's duty under the UCC is to accept the goods and pay for the goods. Under the UCC, what are the seller's remedies? In the event of a breach, by Adrian. In the event of a breach, what are the seller's remedies?
To cover and cure.
Cure is one of the seller's remedies. Cover is the buyer's remedy. So what are the seller's remedies? The seller can, one, repudiate the contract if it appears the buyer is insolvent or the buyer has not paid for the goods. The seller can withhold future deliveries. The seller can engage in resale. Yes, good. Stop delivering the goods. Sell the goods to a third party. Sue for breach of contract. What are the buyer's remedies? Someone said cover. And that means obtain alternate goods from another seller. So the buyer gets a non-conforming delivery of goods that they can't use. They can cover by obtaining conforming goods elsewhere and sue the seller for the extra cost if they have to buy more expensive goods to get the job done. You can sue for breach of contract. If the seller becomes insolvent, the buyer can repudiate the contract. Okay, we talked about the next two. So, congratulations. As long as you know that material we just discussed, and most of you do, you are ready to not just take the quiz, you're ready to pass the quiz. Be sure to submit the correct quiz answers by Sunday, July 25th. There is no live session question this week. If you should run into any concerns along the way, if you need help with your Module 3 assignment, set up a tutoring appointment for yourself. If you need help doing research on Lexis Advance, call Dennis, the librarian. He'd love to help. If your computer crashes, now and at any other time, if the software doesn't work, if WebEx freezes up, call tech support. They're there 24 hours a day. They're very good. And if there's no questions, I will see you all in the Module 3 discussion forum. Have a great week. Thanks, Corinne. Thanks, Jody. Thanks, Kara. Thanks, Stephanie. Thank you, Adrian. Thank you, Tina. Thanks for taking the time to attend the live session. Have a great week.
I wanted to, sorry, I'm blocking the camera. I got your